Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis on different topics related to SSC, DSSB, DDC and other steno competitive exams. So get ready for our high speed dictation without any stop. It is also relevant to indicate that the appellate court, while allowing the special appeal, even though at that point of time the mother of the petitioner had not been acquitted, keeping the equity in favor of the petitioner, had passed an order by which a direction was issued to the respondents to consider the claim of the petitioner for compassionate appointment. It is also apparent from the record that while allowing the appeal, the appellate court was conscious enough that considerable time has lapsed, but in spite of this fact that the mother of the petitioner had not been acquitted at that point of time, the appellate court had directed for consideration of the appointment of the petitioner on compassionate ground in place of her mother. Therefore, at this stage, taking the view that substantial time has lapsed and on the basis of law laid down by Honorable the Apex Court in Umesh Kumar Nagpal within bracket Supra, the claim of the petitioner cannot be considered, cannot be sustained. The records clearly indicate to this court that earlier writ petition number 7638 of 1995 was filed by the mother of the petitioner, which was allowed on 23 to 1998 with direction to give her compassionate appointment on class 4 post. The respondents did not comply with the same and preferred special leave appeal number 1384 of 2009, which was also allowed on 9/9/2014 with specific observation and direction for consideration of the claim of the petitioner instead of her mother for compassionate appointment. Therefore, at this stage, the respondents cannot take plea that substantial time has lapsed in between. Therefore, on this ground, the claim cannot be rejected. The respondent authorities are not empowered to substitute their own view over the judgment of the division bench. Either the respondent authorities should challenge this point before the division bench, or they should file recall application, or they should approach Honorable the Apex Court in this regard. But as the respondents have not adopted any of the aforesaid step and has not filed any appeal against the aforesaid judgment of the division bench, it is binding on the respondent authorities and they cannot substitute their own view over it. Every case has its own facts and circumstances. In this case, the mother of the petitioner has suffered double jeopardy. Her husband was not only murdered, but she was also falsely implicated in the murder of her husband. Her conscience oblique conscience of the court that how she could have maintained her family and proved her innocent in the criminal case for the murder of her own husband. The division bench, considering the facts and circumstances of the case and extreme difficulty faced by the mother of the petitioner, take a sympathetic view and directed the compassionate appointment of the petitioner. Non-compliance of the order of the division bench without being raised before Honorable the Apex Court can be said to be contemptuous, and it is not open to the respondents to defy the same.